Yes, hello. Magandang hapon sa inyong lahat, no? Mag-alas-tres na naman ng hapon at magbabasa-basa na naman tayo ng mga batas, no? Sa ngayon, yung mga babasahin nating batas may kinalaman pa rin sa mercantile or commercial law, no? So, yung una nating topic na hinanap-hanap ko ay tungkol sa business organizations. Unang-una na doon yung single proprietorship. Okay. Ito yung mga... sige, basahin na lang natin, no? Sabi rito, the establishment, management, and operations of this form of business organization is not governed by a special law, unlike in the case of corporations. However, resort to general laws governing civil obligations and contracts or business and commercial transactions may be made. So, di ba nabasa na natin yung mga civil law, especially obligations and contracts. As a general rule, foreigners may put up single proprietorship business in the Philippines in industries where the Constitution and the laws do not impose any restriction or limitation on ownership equity. In the event that non-Philippine nationals are not allowed to form single proprietorship business in a particular industry, he may still proceed with his business venture through other forms of business organizations such as corporation, partnership, or joint venture. Ngayon, nabasa na natin yung corporation code. Basa na rin natin yung partnership under the civil code. So, basahin na lang natin tong paano nabubuo itong single proprietorship, no? A single proprietorship is the simplest form of business organization in the Philippines. It is not encumbered, o ibig sabihin burdened, hindi siya burdened by the strict regulatory laws and rules imposed upon corporations and partnerships. Government registration of a single proprietorship business is simple. It is made through the Bureau of Trade, Regulation, and Consumer Protection of the Department of Trade and Industry. So kung ikaw pala ay single proprietor, magre-rehistro ka sa Bureau of Trade, Regulation, and Consumer Protection na nasa ilalim ng ahensya na Department of Trade and Industry o yung DTI. O sa single proprietorship, ano yung liability ng proprietor? The single proprietor has unlimited liability in the sense that creditors of his business may proceed not only against the assets and property of his business, but after his own personal assets and property. Creditors o yung mga pinagkakautangan niya with whom he had incurred personal debts may also run after the assets and property of his single proprietorship business. Simply put, the law does not make any distinction between his personal affairs and his business transactions. Before the eyes of the law, they are one and the same, his business being a mere extension of his person. Siguro ang magandang example ko rito yung sari-sari store. Kunwari nagtayo ako ng sari-sari store or mini grocery. No, yung mga utang ko na may kinalaman doon sa pagkakatayo ko ng mini grocery ko, ay pwede rin nilang habulin yung mga personal na ari-arian ko. Kunwari yung bahay ko, yung lote ko, yung sasakyan ko, pwede nilang habulin yun kung hindi ako makapagbayad ng utang sa kanila. Hindi kagaya sa korporasyon. Ang korporasyon kasi ay merong separate anong tawag dito, separate personality, 'di ba? Itinuturing siya na isang legal person sa mata ng batas. So yung liability ng corporation ay iba o nahihiwalay dun sa personal liability ng kanyang mga stockholders and ng board of directors, 'di ba? Ganon din sa partnership. Hindi mo pwedeng basta habulin na lamang yung ari-arian ng partnership as to your personal na pagkakautang, hindi ba? So, yung sole proprietorship, it's as if lahat ng utang na may kinalaman doon sa pagtatayo mo ng negosyong yun, is just an extension of yourself. Pwedeng habulin lahat sa'yo. Okay, kasi ikaw lang no? Wala namang Wala ka namang ibang pinakitunguhan. Okay, basahin naman natin yung joint venture, no? Kasi maiksi lang to eh. Joint venture, ayan. Basahin natin yung konsepto niya. Joint venture within the concept of Philippine law is organized or established only for some transient or temporary business objective. It is often characterized as being similar to a partnership in the sense that there exists among the joint venturers commonality of interest and mutual right of control, not to mention the mode by which profits or losses are shared. Joint ventures are usually resorted to by corporations, domestic or foreign-based, which are not allowed to form partnerships or become partners in a partnership. Only individual natural persons are permitted to form partnerships. So ginagawa ito ng mga korporasyon para malinaw, no? Kasi hindi naman sila pwedeng magbuo. Kahit na sabihin na natin may legal personality ang corporation, hindi pwedeng mag-form ng partnership ang San Miguel Corporation, Manny Pangilinan Group, and the Ayala Group, kunwari. Ang pwede nilang gawin ay joint venture, kunwari. Magmimina sila. O kaya magsisik sila ng natural resources. So, joint venture ang pwede nilang gawin kasi malinaw ang sinabi rito. Only individual natural persons, kunwari ako o ikaw or yung teacher mo sa law, si attorney ganito at yung iba pang mga attorney, ang pwede silang mag-form ng partnerships para kunwari sa kanilang law firm. Ganon. So, joint venture, madalas naririnig natin yan sa mga natural resources exploration, mga oil and gas exploration. Kunwari, yung korporasyon natin, makipag-joint venture. Yung korporasyon natin with pahintulot ng appropriate government agency, makiki-joint venture tayo sa isang korporasyon ng China na may pahintulot din ng ating agency, mga ganon. So, yun po ang joint venture. Okay, magpunta naman tayo sa foreign corporation. Okay. Okay, sabi rito, foreign investments, paano ginagawa, no? Foreign investments in the Philippines may be made under any of the following modes. Number 1, by establishing a domestic branch office or operation. Number 2, by establishing a Philippine representative office. Number 3, by operating through a business association in the Philippines. Number 4, by operating through a local subsidiary which may be owned entirely or partially by the foreign business entity. Number 5, by establishing joint venture arrangement with a local corporation or business organization. And number 6, by establishing an affiliate in the Philippines. So, yun yung mga pamamaraan, ano, kung paano nag-i-invest yung mga foreigners sa atin, yung mga foreign corporations sa atin. Among the types of business organizations allowed under Philippine law, a corporation is the most feasible mode of establishing business in the Philippines. The choice of a particular mode of establishing corporate presence in the Philippines will depend to a great extent on the kind of business in which a foreign investor wants to engage. Unless falling within the restricted list where foreign ownership is limited to a certain percentage of equity, a foreign investor may establish corporate presence in the Philippines directly, for an example, by establishing a branch office or by creating a wholly owned subsidiary. Excuse me po. So, pwede nga silang gumawa ng subsidiary nila dito o ng branch office nila dito o ng magtalaga sila ng representative na nakatira dito. Okay. Okay, foreign corporation, ano yung governing law? Basahin natin. As far as domestic corporations are concerned, the governing law over their creation, formation, management, dissolution, and liquidation is the Corporation Code of the Philippines. Binasa na natin yan. This same law also governs the corporate relationships between the corporation and its shareholders, the public, and the government. As far as foreign corporations, however, are concerned, the law governing their creation, formation, dissolution, and liquidation is the law of the country where such foreign corporations were organized or established. This is a principle of international law which is fully recognized in Philippine jurisdiction. Further, Philippine corporation laws were basically patterned after American corporation and enterprise laws. Consequently, it is no wonder that when unique situations confront Philippine courts, resort to American laws and jurisprudence is made to resolve them. Tama yung sinasabi nung dati kong teacher na sobrang daming batas, even yung rules of court natin ay ginaya natin sa Amerika, no? Foreign corporation right to sue. Whether a foreign corporation is possessed of the right to sue in the Philippines is determined by follows. Tingnan natin kung pwede sila maghabla, no? Number one, if the foreign corporation is transacting or doing business in the Philippines with a license, it has the right to sue within the jurisdiction of the Philippines. Ito yung lisensyang sinisecure sa appropriate government agency ayon sa Corporation Code. Ikalawa, if it is transacting or doing business without a license, it cannot sue. Okay, number three, if it is not transacting or doing business in the Philippines, it can sue even if it is not possessed of any license. Okay, kapag hindi naman siya nagnenegosyo rito, pwede siyang maghabla kahit na wala siyang lisensya kasi kailangan lang naman ng lisensya to transact dito sa Pilipinas, di ba? Okay, foreign corporation, right to be sued. Oh, tayo naman ang mga habla sa kanila. A foreign corporation may be sued in the Philippines. Number one, if it is transacting or doing business in the Philippines with a license. And number two, if it is transacting or doing business in the Philippines without a license. Pwede natin silang ihabla, wala kayong karapatang magnegosyo rito. However, if it is not transacting or doing business in the Philippines and does not have any license to so transact or do business in the Philippines, it cannot be sued in the Philippines for lack of jurisdiction. Hindi naman siya nagnenegosyo rito, hindi niya naman pinagkakakitaan yung bansa natin. Wala naman siyang lisensya na magnegosyo rito. So, anong jurisdiction natin sa kanya? Ano ring magiging cause ng paghahabla natin sa kanya, di ba? Foreign corporation registration requirement and procedure. Foreign corporations intending to operate in the Philippines through the modes allowed by law should register with the Philippine Securities and Exchange Commission. Ganun din naman pag magtatayo tayo ng domestic corporation, kunwari ako at saka apat ko pang kaibigan, nagtayo kaming korporasyon, paparehistro mo rin naman sa SEC. Such registration is necessary to give legal personality thereto. Consequently, duly registered foreign corporations are treated as artificial beings possessed of all rights, benefits, and privileges pertinent to being a corporate citizen, such as the capacity to sue and be sued, and or invoke the protection of Philippine laws in all their business and commercial dealings. Basahin natin nga yung procedure. The procedure for the registration of a domestic or foreign corporation may be summed up as follows. So kung may tropa kayo na foreign corporation na gustong magparehistro dito, no? Or domestic corporation, no? Tingnan natin. First step daw is determination of whether the corporation is going to engage or do business in an industry where the Philippine Constitution and laws impose restrictions as to foreign equity ownership. Yun, kailangan mong pagtuunan yun kung magbibigay ka ng payo sa isang foreign company, no? If the restriction or prohibition is absolute in nature, the foreign corporation will not be permitted to set up in the Philippines. Kunwari, media. Example niyan, di ba? Yung media broadcasting, ganyan. If the restriction or prohibition is not absolute, a foreign corporation may be allowed to be set up in the Philippines, but just the same, it must comply with a strict foreign equity ownership limitation. Example niyan, yung CNN Philippines. In case there is no such limitation or prohibition, absolute or otherwise, the foreign corporation may directly engage in business in the Philippines under any of the permissible modes described above. Second step, confer with the proper government agency regulating or supervising the particular industry where the foreign corporation desires to engage in. A certification from said appropriate government agency that it is not so prohibited from engaging in a business falling with that industry must be secured. Certain industries require this certification such as the banking industry, insurance, and etc. Pupunta ka sa proper government agency. Bukod po ito sa registration sa SECA, kung ang may kinalaman ka nga daw sa banking ang industriya na set up ng isang foreign corporation, magpupunta ka saan? Di malamang sa BSP siguro, no? Third step, proceed with the filing of the application with the Securities and Exchange Commission, which application must be accompanied by the said certification. So yung application mo, nakalagay yata, kung di ako nagkakamali, yung form ng application mo sa corporation code or downloadable naman yun sa internet, di ba? Naka-attach din doon syempre yung na-secure mong certification from the appropriate government agency. The SEC will then examine the documents submitted and consequently release the registration papers in due time. At tignan naman natin yung documentation, no? Sabi rito, in the case of existing foreign corporations intending to set up a branch or representative office in the Philippines, the following documentation process shall be undertaken. Una daw, verification of the name of the corporation with the SEC. Okay, closed, I open parenthesis, a name verification slip is issued by the SEC for this purpose. Closed. To determine whether there is similarity in the corporate name with any existing corporations registered with the SEC. Ikalawa, a copy of the board resolution of the corporation duly certified by the corporate secretary and or members of the board that the corporation is authorized to establish an office in the Philippines and naming or designating therein its authorized agent in the Philippines. Kasi mahalaga yun. Kailangan may authorized agent sila sa Pilipinas na pwedeng tumanggap ng mga summons, di ba? Pwedeng tumanggap ng summons as if dineliver yung summons doon sa foreign corporation. Ikatatlo, duly audited financial statements covering the year immediately preceding the filing of the application. Ikaapat, certified copies of the original articles of incorporation duly filed in the country of origin or yung so-called home country nila and translated in English. And number 5, verified proof of inward remittance such as bank certificate or credit advice. Letter B naman, in the case of domestic corporations naman, okay. Mari, tayo naman yung magtatayo ng korporasyon. Ako, along with my 5 friends. The following documentation requirements should be complied with. Number 1, copy of the proposed articles of incorporation. Number 2, name verification slip. Ayan, SEC ang magbibigay niyan sa'yo. Number 3, certificate of deposit issued by a bank to show proof that the paid-up capital portion of the authorized capital stock is duly deposited in said bank. Kasi di ba may, kung di ako nagkakamali, merong certain percentage, nalimutan ko na agad ng authorized capital stock ang dapat na paid up na. Okay, number 4, copy of the alien certificate of registration, special investors resident visa, o di naman other types of visa. And number 5, proof of inward remittance which is required for non-resident aliens. Okay. Sabi pa rito, okay, Philippine laws allow one or more foreign corporations to merge, okay, or consolidate with one or more domestic corporations in the Philippines. In the event, however, that the absorbed corporation is the foreign corporation, okay, yung inabsorb ng isang corporation sa Pilipinas ay yung foreign corporation na nakipag-merge, the latter should file a petition for withdrawal of its license with the Securities and Exchange Commission. Wala na, na-absorb na siya ng Philippine Corporation, so hindi niya na kailangan ng lisensya. It is required na mag-file na siya, yun nga, sabi rito, ng petition for withdrawal of its license with the SEC. Okay, so doon na tayo natapos na unawain itong mga business organizations. Mamaya magbabalik ako yung CCR lamang. Magbabasa naman tayo tungkol sa the bulk sales law. Okay, so okay, nagbabalik para naman basahin yung bulk sales law. Diba? Basahin natin siya. Magsimula na tayo sa Section 2 kasi sabi sa Section 1, this act shall be known as the bulk sales law. Ayan ha. Section 2, sale and transfer in bulk. O, ibig sabihin nito yung bulto. Any sale, transfer, mortgage, or assignment of a stock of goods, wares, merchandise, provisions, or materials otherwise than in the ordinary course of trade and the regular prosecution of the business of the vendor, mortgagor, transferor, or assigner, or sale, transfer, mortgage, or assignment of all, or substantially all, of the business or trade theretofore conducted by the vendor, mortgagor, transferor, or assigner, or of all, or substantially all of the fixtures and equipment used in and about the business of the vendor, mortgagor, transferor, or assigner shall be deemed to be a sale and transfer in bulk in contemplation of this act. Okay. Hindi lang pala sale, kundi transfer, mortgage, or assignment ng mga bulto-bultong mga produkto, ano? Provided, however, that if such vendor, mortgagor, transferor, or assigner produces and delivers a written waiver of the provisions of this act from his creditors as shown by verified statements, then, in that case, the provisions of this section shall not apply. So, kung may waiver daw siya of the provision of this act from his creditors as shown by verified statements, so pwedeng i-waive yung provision ng batas na ito. No? Section 3, Statement of Creditors. It shall be the duty of every person who shall sell, mortgage, transfer, or assign any stock of goods, wares, merchandise, provisions, or materials in bulk for cash or credit, binibenta niya for credit or for cash, before receiving from the vendee, mortgagee, or his or its agent or representative any part of the purchase price thereof, or any promissory note, memorandum, or other evidence therefore to deliver such vendee, mortgagee, or agent, or if the vendee, mortgagee, or agent be a corporation, then to the president, vice, treasurer, secretary, or manager of said corporation, or if such vendee or mortgagee be a partnership firm, then to a member thereof, a written statement sworn to substantially as herein provided of the names and addresses of all creditors to whom said vendor or mortgagor may be indebted, okay, together with the amount of indebtedness due or owing or to become due or owing by said vendor or mortgagor to each of said creditors, which statement shall be verified by an oath of the following effect. So dapat pala merong statement ka ng iyong mga pinagkakautangan kung ikaw daw ay vendor, no? Ito may format dito. Philippine Islands, province or city of, kunwari ako, Subic, Zambales. Before me, the undersigned authority personally appeared. So ako kunwari yung vendor. O ako yung nagsasanla. Loloray, agent or representative as the case may be, bearing cedula number 12345, issued at Chorba, by me being first duly sworn upon this oath, deposes and states that the foregoing statement contains the name of all the creditors of Loloray, together with their addresses, and that the amount set opposite each of said respective names is the amount now due and owing, and which shall become due and owing by Loloray to such creditors, and that there are no creditors holding claims due or which shall become due for or on account of goods, wares, merchandise, provisions, or materials purchased upon credit or on account of money borrowed to carry on the business of which said goods, wares, merchandise, provisions, or materials are a part other than set forth in said statement. So yung mga pinagkakautangan ko ay walang kinalaman sa aking mga binibenta. Ayan, yun ang ibig sabihin din. Subscribed and sworn before me at this Chorba Day of Chorba at 2002. Yeah. Section 4, fraudulent and void sale, transfer, or mortgage. Whenever daw any person shall sell, mortgage, transfer, or assign any stock of goods, wares, merchandise, provisions, or materials in bulk for cash or on credit, and shall receive any part of the purchase price or any promissory note or other evidence of indebtedness for said purchase price or advance upon mortgage without having first delivered to the vendor or mortgagee or to his or its agent or representative the sworn statement provided for in Section 3 hereof. Okay, hindi niya pa na-deliver yung nakalagay sa Section 3, itong statement of creditors. Okay. Saan na ako? And without paying the purchase price or mortgage money of the said property to the pro rata payment of the bona fide claims or claims of the creditors of the vendor or mortgager as shown upon such sworn statement, he shall be deemed to have violated this act, and any such sale, transfer, or mortgage shall be fraudulent and void. Siguro iniwasan to para yung nagtitinda ka na tapos may utang ka pa pala. Alam mo yun, hindi ka pa nakakabayad ng utang, tapos nagtitinda ka. Parang ganun siguro. According dito sa bulk sales law, kailangan kung may pinagkakautangan yung nagtitinda o yung nagsasanla, nakasaad dito sa kanyang statement of creditors. So pag hindi mo wala kang statement of creditors, 'di ba? It shall consider the transaction, yung pagbebenta mo o yung pagsasanla mo ng mga bulto na produkto mo shall be fraudulent and void. Section 5, Inventory. It shall be the duty of every vendor, transferor, mortgager, or assigner at least 10 days before the sales, transfer, or execution of a mortgage upon any stock of goods, wares, merchandise, provisions, or materials in bulk to make a full detailed inventory thereof and to preserve the same, showing the quantity and so far as is possible, with the exercise of reasonable diligence, the cost price to the vendor, transferor, mortgager, or assigner of each article to be included in the sale, transfer, or mortgage, and notify every creditor whose name and address is set forth in the verified statement of the vendor, transferor, mortgagor, or assigner at least 10 days before transferring possession thereof personally or by registered mail of the price, terms, conditions of the sale, transfer, mortgage, or assignment. Section 6. Any vendor, transferor, mortgagor, or assigner of any stock of goods, wares, merchandise, provisions, or materials in bulk, sabi niyan ganyan, who shall knowingly or willfully make or deliver or cause to be made or delivered a statement as provided for in Section 3 hereof, which shall not include the name of such creditors. Hindi niya sinulat yung mga pinagkakautangan niya. Hindi niya rin sinulat yung correct amount due and to become due to each of them, shall be deemed to have violated the provisions of this act. Section 7. It shall be unlawful for any person, firm, or corporation as owner of any stock of goods, wares, merchandise, provisions, or materials daw, in bulk, okay, in bulto, to transfer title to the same without consideration or for a nominal consideration only. Ibig sabihin, hindi ka binayaran, tinransfer mo lang. For what? For cash, for credit, walang, napakaliit na consideration. Kasi, parang anong klaseng transfer yan? Parang nanloloko ka. So, it shall be unlawful. Okay. Section 8. Nothing in this act contained shall apply to executors, administrators, receivers, assignees in insolvency or public officers acting under judicial process. Okay. Wala silang kinalaman dito. Section 9. The sworn statement containing the names and addresses of all creditors of the vendor or mortgager provided for in Section 3 shall be registered in the Bureau of Commerce. For the registration of each sworn statement, a fee of 5 pesos shall be charged to the vendor or mortgager of the stock of goods, wares, merchandises, materials in bulk. So, yung sworn statement na sinasabi sa Section 3, yung statement of creditors na mga pinagkakautangan mo, ay irerehistro yon nung nagtitinda, okay, sa Bureau of Commerce. Section 10, the provisions of this act shall be administered by the Director of the Bureau of Commerce and Industry, who is hereby empowered with the approval of the department head to prescribe and adopt from time to time such rules and regulations as may be deemed necessary for the proper and efficient enforcement of the provisions of this act. Section 11. Any person violating any provision of this act upon conviction thereof be punished by imprisonment of not less than 6 months, not more than 5 years, or fined in sum not exceeding 5,000 pesos, or both. Such imprisonment and fine in the discretion of the court. Okay, so may kulong ito, yung paglabag dito. So, sa mga nagbebenta po in bulk o in bulto, kailangan meron kayong statement ng inyong mga pinagkakautangan, kung magkano ito, kailan ito due. Okay? Kailangan meron kayong ganon. Pinakamahalaga yun. Diba? It is your duty raw sabi nila. It shall be your duty bago kayo magbenta, bago kayo tumanggap ng bayad nung binibenta ninyo, dapat kayo mag-provide ng statement of creditors. Hindi lang para sa binibentahan ninyo, kundi para na rin may rehistro dun sa Bureau of Commerce. Okay? So, yun po ang Bulk Sales Law Act number 3952. Okay? Maiksi lang siya. Sana naman ano susunod natin babasahin. Merong Act number 4164. Tignan nga natin ito. Subukan natin basahin. Okay. Sabi rito, an act to prevent the excessive increase in the price of certain prime necessities of life on occasion of a public calamity, penalizing the violation thereof and for other purposes. Maganda ito hindi ka pwedeng basta magtaas ng presyo ng prime commodities kahit pa may kalamidad, no? Tingnan natin. Section 1. Whenever the Governor General shall certify in a proclamation that a public calamity exists in any given locality within the Philippine Island as a result of any typhoon, earthquake, or other acts of God or of similar nature. Governor General, yung governor na lang ng lalawigan para mas maintindihan natin. Sabi, it shall be unlawful for any person, firm, or corporation in such locality from and after the last date of the publication of said proclamation, as hereinafter provided, and during the existence of such calamity, bawal daw, number 1, to sell or offer for sale palay, rice or corn, building or construction materials, and other prime necessities of life to be specified in such proclamation at prices higher by 25%, okay, or more over and above the average current local price of such commodities 1 month previous to the occurrence of such public calamity as may be determined by the Director of Commerce. Bawal daw yun. Kaya kung mapapansin natin, nagtataas naman sila ng presyo, pero bawal nga lang yung overpriced. Ibig niya sabihin dito yung 25% yung idinagdag. 25%, kunwari 100 pesos yung palay, kunwari lang. Ginawa mong 125 na, bawal daw yun. Kaya ang ginagawa na lang nila, 120 na lang. Pangalawa, bawal din daw to aggravate o palalain yung crisis by refusing for the purpose of profiteering to sell at the legal price or by hiding, concealing, or hoarding the goods or commodities for the same purpose. As soon as the governor shall become satisfied that the existence of a public calamity as certified by him dun sa kanyang proclamation has already ceased, he shall by like proclamation declare the cessation of such public. Ayan, medyo naputo lang yung internet natin, medyo nagloko na. And upon proclamation daw na tumigil na yung kalamidad, no? Yung state of calamity. Nag-proclaim na si governor na wala na ito, di ba? Such proclamation, the effects of this section with regard to the locality or localities affected shall thereby cease. Okay. Sabi pa rito, Section 2, the Governor General shall cause the proclamations required in the preceding section to be published in the official gazette and for 3 consecutive issues in 2 daily newspapers of general circulation in the islands, 1 in Spanish and another in English. Aluma na ito. Panahon pa ng Kastila itong batas na ito Ikatatlo daw, Section 3, the governor. Kaya pala Governor General pa, panahon pa ng Kastila itong batas na to. Pero may epekto pa rin to. The governor during the period of emergency herein provided for, if in his judgment, public order so requires, order the seize of a commodity, material, or merchandise or prime necessity, tapos sell it to the public at the price herein authorized and reimburse to the owner of the same its legal price. Pwede niyang gawin yun. So kung ako yung gobernador pala, meron state of calamity, nakita ko may mga nagsasamantala. Pwede kong kunin yun ayon sa batas, babayaran ko siya sa legal price na sinasabi ng batas at ibibenta ko rin yun sa legal price. Okay. Kaya dapat di kikita si Gob doon, ha? Section 4, any person, firm, or corporation violating the terms of this act shall be punished by a fine of not less than 200 pesos. Baka 200,000 na to ngayon. Or by imprisonment for not less than 2 months, nor more than 2 years, or both at the discretion of the court. And the forfeiture of the corpus delicti, o forfeiture nung mga material na binibenta mo na overpriced. In the case of a firm or corporation, the manager or administrator thereof shall be criminally responsible for the violation of this act by such firm or corporation. Section 5, this act shall take effect upon its approval. Okay, so natapos na tayo dito sa Act 4164 o yung act to prevent the excessive increase in the price of certain prime necessities of life in the occasion of a public calamity. At tapos pinipinalize niya o pinarurusahan yung mga violations thereof. Magpunta naman tayo sa Carriage of Goods by Sea Act. Okay? Sahin nga natin to. Ang pangalan nito ay Public Act number 521 na pinagmagatang Carriage of Goods by Sea Act. Okay. Section 1, that the provisions of Public Act number 521 of the 7th Congress of the United States, wag na yan, whatever, ginaya natin yung United States, oo na. Title 1, Section 1. Okay, when used in this act, letter A, the term carrier includes the owner of the owner or the charterer who enters into a contract of carriage with a shipper. So either yung owner ka ng barko o ikaw yung charterer, ikaw yung nagrenta dun sa barko at pumasok ka sa kontrata ng carriage with the shipper. Letter B, the term contract of carriage applies only to contracts of carriage covered by a bill of lading or any similar document of title insofar as such document relates to the carriage of goods by sea, including any bill of lading or any similar document as aforesaid issued under or pursuant to a character party from the moment at which such bill of lading or similar document of title regulates the relations between a carrier and the holder of the same. Letter C, the term goods includes goods, wares, merchandise, and articles of every kind whatsoever except live animals and cargo, which by the contract of carriage is stated as being carried on deck and is so carried. Letter D, the term ship means any vessel used for the carriage of goods by sea. And letter E, the term carriage of goods covers the period from the time when the goods are loaded to the time when they are discharged from the ship. Section 2, risks. Subject to the provisions of Section 6, under every contract of carriage of goods by sea, the carrier in relation to the loading, handling, stowage, carriage, custody, care, and discharge of such goods shall be subject to the responsibilities and liabilities and entitled to the rights and immunities herein after set forth. Ano ba yung mga responsibilities and liabilities ng carrier? Section 3. The carrier shall be bound before and at the beginning of the voyage to exercise due diligence. To exercise mainam na pag-iingat. To letter A, to make the ship seaworthy. Letter B, properly man, equip, and supply the ship. Letter C, make the holds, refrigerating, and cooling chambers and all other parts of the ship in which goods are carried fit and safe for the reception, carriage, and preservation. Uh, Ikalawa naman, the carrier shall properly and carefully load, handle, stow, carry, keep, care for, and discharge the goods carried. Number 3, after receiving the goods to his carrier or the master or agent of the carrier, shall, on demand of the shipper, issue to the shipper a bill of lading showing, among other things, ito yung dapat ipakita. Ito yung dapat ipakita ni carrier, no? Doon sa ang tawag dito, doon sa master or agent of the... Wait lang, nalito ako. After receiving the goods in his carrier or the master or agent of the carrier, shall on demand of the shipper issue to the shipper a bill of lading showing, among other... Ito, sige. Ako yung shipper. Sa barko ko, kinarga nyo na yung dokumento. So, magde-demand ako na ipakita nyo sa akin yung letter A, the loading marks necessary for identification of the goods as the same are furnished in writing by the shipper before the loading of such goods starts, provided such mark share ba to? Mark share, hindi ko alam ito eh. Stamped or otherwise shown clearly upon the goods if uncovered in such a manner as should ordinarily remain legible until the end of the voyage. Letter B, either the number of packages or pieces or the quantity or weight as the case may be as furnished in writing by the shipper. Letter C, the apparent order and conditions of the goods, provided that no carrier, master, or agent of the carrier shall be bound to state or show in the bill of lading any marks, number, quantity, or weight which he has reasonable ground for suspecting not accurately to represent the good actually received, or which he has had no reasonable means of checking. Okay, ikaapat, such bill of lading daw shall be prima facie evidence of the receipt by the carrier. Doon nga sa example ko, ako yung may-ari ng barko, ako yung charterer. Isasakay nyo sa barko ko yung mga goods ninyo, ako yung carrier. So dahil natanggap ko yung bill of lading ninyo, it is the prima facie evidence na natanggap ko yung goods from the shipper kasi shinip mo sa barko ko eh. Pinasok mo sa barko ko yung yung mga goods mo at tinanggap ko by the bill of lading, sabi. Okay. Number 5, the shipper shall be deemed to have guaranteed to the carrier the accuracy at the time of shipment of the marks, number, quantity, and weight as furnished by him. Dapat accurate yun. And the shipper shall indemnify the carrier against all loss, damages, and expenses arising or resulting from inaccuracies in such particulars. The right of the carrier to such indemnity shall in no way limit his responsibility and liability under the contract of carriage to any person other than the shipper. Tandaan natin, may nagkamali yata ang example kanina. Yung shipper, yun yung may-ari ng goods. Ipapakarga niya, ipapadala niya kay carrier, yung may-ari ng barko o yung nagrenta sa barko para dalhin ko yung goods ni shipper. Okay. Number 6, unless notice or loss or damage in the general nature of such loss or damage by given in writing to the carrier or his agent at the port of discharge or at the time of the removal of the goods into the custody of the person entitled to delivery thereof under the contract of carriage, such removal shall be prima facie evidence of the delivery by the carrier of the goods as described in the bill of lading. If the loss or damage is not apparent, the notice must be given within 3 days of the delivery. Okay, said notice of loss or damage may be endorsed upon the receipt for the goods given by the person taking delivery thereof. The notice in writing need not be given in the state of the goods has at the time of the receipt been the subject of joint survey or inspection. In any event, the carrier and the ship shall be discharged from all the liability in respect of loss or damage unless suit is brought within 1 year after delivery of the goods or the date when the goods should have been delivered. So parang may 1 year prescription period. Pagka na-damage yung goods mo, sa pagkaka-deliver sa loob ng 1 taon, pwede ka maghabla doon sa carrier. Provided that if a notice of loss or damage, either apparent or concealed, is not given as provided for in this section, That fact shall not affect or prejudice the right of the shipper to bring suit within 1 year after the delivery of goods or the date when the goods should have been delivered. So, dapat kapag may damage, itong si carrier, okay, dapat siyang magbigay ng notice doon sa shipper na, uy, yung mga pinaship mo sa akin na goods mo ay may damage. In the case of any actual or apprehended loss or damage, the carrier and the receiver shall give all reasonable facilities to each other for inspecting and tallying the goods. Number 7, after the goods are loaded, the bill of lading to be issued by the carrier. Okay, ang mag-i-issue ng bill of lading ay yung carrier, master or agent of the carrier to the shipper. Shall, if the shipper so demands, be a shipped bill of lading. Okay. So, kunwari, doon sa example ko, ako yung carrier. O ako yung master o agent ako ng carrier. Ako yung magdadala ng goods mo. I-issuehan kita ng bill of lading dahil ikaw si shipper, i-issuehan kita, nakalagay daw dapat doon, shipped. Ibig sabihin, dinadala na namin. Okay. O nakakarga na. Okay. Nasa amin ng mga carrier ang responsibilidad. Provided that if the shipper shall have previously taken up any document of title to such goods, he shall surrender the same as against the issue of the shipped bill of lading, but at the option of the carrier, such document of title may be noted at the port of shipment by the carrier, okay, master or agent, with the name or names of the ship or ships upon which the goods have been shipped, and the date or dates of shipment, and when so noted, the same shall for the purpose of this section be deemed to constitute a shipped bill of lading. Number 8 ng section 3 pa rin, no? Any clause, covenant, or agreement in a contract of carriage relieving the carrier of the ship from liability for loss or damage to or in connection with the goods arising from negligence, fault, or failure in the duties and obligations provided in this section, or lessening such liability otherwise than as provided in this act, shall be null and void and of no effect. Hindi mo pwedeng alisin yung pananagutan ng carrier. A benefit of insurance in favor of the carrier or similar clause shall be deemed to be a clause relieving the carrier from liability. So, bawal yun. Sundin lang natin yung nakalagay sa batas. Rights and Immunity, Section 4. Number 1, neither the carrier nor the ship shall be liable for a loss or damage arising or resulting from unseaworthiness unless caused by want of due diligence on the part of the carrier to make the ship seaworthy and to secure that the ship is properly manned, okay, equipped, and supplied. So, kung hindi kompleto ang supply mo, hindi mo sinigurong maayos yung barko mo, magiging liable ka kung ikaw yung carrier, di ba? Di ba? Pero kung ginawa mo naman lahat, siniguro mong seaworthy yung barko mo, properly manned, etc., etc., di ba? Properly supplied, tapos meron siyang holds refrigerating, cooling chambers, and other parts ng ship, hindi ka na magiging liable, sabi nila. Okay, sabi pa rito, whenever loss or damage has resulted from unseaworthiness, the burden of proving the exercise of due diligence shall be on the carrier or other person claiming exemption under this section. So, ako yung carrier, nasira yung mga goods mo na shinip mo sa akin, ikaw yung shipper. Kailangan kong patunayan na hindi, ginawa ko lahat ng due diligence. Maayos yung barko ko, seaworthy, kompleto lahat, kompleto tao, kompleto gamit, ganon. Sabi pa rito, neither the carrier nor the ship shall be responsible for loss or damage arising resulting from. So, yung carrier, hindi daw kasalanan ng carrier o ng barko, yung damage arising from letter A, act, neglect, or default of the master, mariner, pilot, or the servants of the carrier in the navigation or in the management of the ship. Okay, neglect ng mga tao dun. Letter B, fire unless caused by the actual fault or privity of the carrier. And letter C, perils, dangers, and accidents of the sea or other navigable water. Letter D, act of God. Letter E, act of war. Letter F, act of public enemies. Ito yung mga, kunwari, gawain ng mga pirata. Letter G, arrest or restraint of princes, rulers, or people, or seizure under legal process. Letter H, quarantine restrictions. Yan, wala tayong magagawa yan, lalo na ngayon, COVID. Letter I, act or omission of the shipper or owner of the goods, his agent or representative. Letter J, strikes or lockouts or stoppage or restraint of labor from whatever cause, whether partial or general, provided that nothing herein contained shall be construed to relieve a carrier from responsibility for the carrier's own acts. Letter K, riots and civil commotions. Letter L, saving or attempting to save life or property at sea. Letter M, wastage in bulk or weight or any other loss or damage arising from inherent defect, quality, or vice of the goods. Letter N, insufficiency or packing. Siguro, insufficiency of ito. Hindi sapat yung pagkakapack. Letter O, insufficiency or inadequacy of marks. Letter P, latent defects not discoverable by due diligence. And letter Q, any other cause arising without the actual fault and privity. Walang fault at walang kamuwang-muwang si carrier, and without the fault or neglect of his agents or servants. But the burden of proof shall be on the person claiming the benefit of this exception to show that neither the fault or privity of the carrier nor the fault or neglect of the agents or servants of the carrier contributed to the loss or damage. So, kailangan kung ako yung carrier, ginawa ko lahat, kumpleto ako sa tao, seaworthy yung aking barko, kumpleto ang equipment ko, lahat-lahat, kumpleto dokumento ko, kailangan kong patunayan yon para makaklaim ako ng exemption under this act. Okay, number 3. Number 3 ng section 4 pa rin, ha. Medyo nakakalito to. Okay, the shipper shall not be responsible for loss or damage sustained by the carrier or the ship arising or resulting from any cause without the act or neglect of the shipper, his agents, or his servants. So, kung ikaw, shipper ka, pinapadala mo sa akin, carrier ako, yung goods mo, wala ka syempre responsibilidad sa damage na masusustain ko kung wala ka namang ginawang neglect o kasalbahihan, di ba? Siyempre, kung naglagay ka ng granada doon o may naiwan kang bomba doon tapos sumabog yung barko ko, ako yung carrier, o siyempre, may kasalanan ka. Letter 4, any deviation in saving or attempting to save life or property at sea or any reasonable deviation shall not be deemed to be an infringement or breach of this act or of the contract of carriage, and carrier shall not be liable. Okay, si carrier daw shall not be liable for any loss or damage resulting therefrom. Provided, however, that if the deviation is for the purpose of loading or unloading cargo or passengers, it shall be prima facie be regarded as unreasonable. So, yung nag-deviate ka para iligtas mo yung barko ninyo at yung mga buhay nyo, walang problema yun. Pero yung nag-deviate ka para mag-unload ka ng cargo, magsakay ka daw ng mga pasahero, it shall be prima facie be regarded as unreasonable. Number 5, neither the carrier nor the ship shall, in any event, be or become liable for any loss or damage to or in connection with the transportation of goods in an amount exceeding $500 per package, dollars na sinabi dito, of lawful money of the U.S. or in case of goods not shipped in packages per customary freight unit or the equivalent of that sum in other currency, unless the nature and value of such goods have been declared by the shipper before the shipment and inserted in the bill of lading. This declaration, if embodied in the bill of lading, shall be prima facie evidence but shall not be conclusive on the carrier. So, kung shipper ka, kailangan mong ideklara yung uri ng goods mo, no? O maaaring may perishable dyan, o mayroong fragile, etc. By agreement between the carrier, yung master or agent of the carrier, and the shipper. O, ako kunwari ulit si carrier, ikaw yung shipper. Okay. Nag-agree tayo, nagsang-ayon tayo. Another maximum amount than that mentioned in this paragraph may be fixed, provided that such maximum shall not be less than the figure above named. So, pwede tayo magsabi $600, pero hindi pwedeng $499. In no event shall the carrier be liable for more than the amount of damage actually sustained. Okay. Sabi pa rito, neither the carrier, okay, nor the ship shall be responsible in any event for loss, damage to, or in connection with the transportation of the goods if the nature or value thereof has been knowingly and fraudulently misstated by the shipper in the bill of lading. Number 6 ng section 4 pa rin, goods of an inflammable explosive or dangerous nature to the shipment, whereof the carrier, master, or agent of the carrier has not consented with knowledge of their nature and character, may, at any time before discharge, be landed at any place or destroyed or rendered innocuous by the carrier without compensation, and the shipper of such goods shall be liable for all damages and expenses directly or indirectly arising out of or resulting from such shipment. If any such goods shipped with such knowledge and consent shall become a danger to the ship or cargo, they may in like manner be landed at any place or destroyed or rendered innocuous by the carrier without liability on the part of the carrier, except to general average if any. Okay, para lamang ito sa mga inflammable, explosive, or dangerous na shipment, no? Basahin naman natin, surrender of rights and immunities and increase of responsibilities and liabilities. Section 5. A carrier shall be at liberty to surrender in whole or in part all or any of his rights and immunities, or to increase any of his responsibilities and liabilities under this act, provided such surrender or increase shall be embodied in the bill of lading issued to the shipper. So yung bill of lading na ibibigay ni carrier, yung nagkakarga ng goods, dun kay shipper, yung nagpapakarga ng goods, pwedeng ilagay doon yung surrender ng kanyang liability. The provisions of this act shall not be applicable to charter parties. But if bills of lading are issued in the case of a ship under a charter party, they shall comply with the terms of this act. So, ang keyword doon, yung bill of lading, no? Pag kahit charter party pa yan, pero nag-issue ka ng bill of lading, you shall comply with this Carriage of Goods by Sea Act. Okay. Special conditions, sabi niya rito. Section 6, notwithstanding the provisions of the preceding section, a carrier, master, or agent of the carrier, and the shipper shall, in regard to any particular goods, be at liberty to enter into any agreement in any terms as to the responsibility and liability of the carrier for such goods, and as to the rights and immunities of the carrier in respect to such goods, or his obligation to seaworthiness, or the care or diligence of his servants or agents in regard to the loading, handling, stowage, carriage, custody, care, and discharge of the goods carried by sea, provided that in this case no bill of lading has been or shall be issued, and that the terms agreed shall be a non-negotiable document and shall be marked as such. Okay? So, yun ang keyword. Pwede kayong magkaroon ng kasunduan ng isang sarili nyong document. Yan. Nahulog. Ng kasunduan ng sarili ninyong document. Ba't lumaki yung mukha ko? Yan. Ay. Yan. Pwede magkasunduan yung carrier at saka yung shipper. Provided na hindi ka na mag-i-issue ng bill of lading. Yung kasunduan nyo na daw na yun shall be a non-negotiable document and shall be marked as such. Any agreement so entered into shall have full legal effect, provided that this section shall not apply to ordinary commercial shipments made in the ordinary course of trade, but only to other shipments where the character or condition of the property to be carried, or the circumstances, terms, and conditions under which the carriage is to be performed are such as reasonably to justify a special agreement. Section 7. Nothing contained in this act shall prevent a carrier or a shipper from entering into any agreement, stipulation, condition, reservation, or exemption as to the responsibility and liability of the carrier or the ship for the loss or damage to or in connection with the custody and care and handling of goods prior to the loading on and subsequent to the discharge from the ship on which the goods are carried by sea. Section 8. The provisions of this act shall not affect the rights and obligations of the carrier under the provisions of the Shipping Act 1916 or under the provisions of sections 4281 to 4292 inclusive of the revised statutes of the U.S. or of any amendments thereto, or under the provisions of any other enactment for the time being in force relating to the limitation of the liability of the owners of seagoing vessels. Okay, papahinga lang ako. Babalikan natin si Title 2. Okay, meron pa tayong Title 2. Mahaba-haba rin pala din tong si Carriage of Goods by Sea Act. So ano na yung mga nabasa natin? Business Org, Bulk, Act 4164. Sige, balik ako ah. Okay, so tapusin na natin tong Carriage of Goods by Sea Act, no? Papaalala ko lang ulit, yung mga binabasa natin ngayon, lahat ng mga batas na binasa natin ngayon ay may kinalaman pa rin sa mercantile law o sa commercial law, no? So nandito na tayo sa Title 2 ng Carriage of Goods by Sea Act, okay? Section 9. Nothing contained in this act shall be construed as permitting a common carrier by water to discriminate between competing shippers similarly placed in time and circumstances, either letter A, with respect to their right to demand and receive bills of lading subject to the provisions of this act. So may karapatan sila to demand and receive bills of lading, or letter B, when issuing such bills of lading, either in surrender of any of the carrier's rights and immunities or in the increase of any of the carrier's responsibilities and liabilities pursuant to Section 5, Title 1 of this Act, at letter C, in any other way prohibited by the Shipping Act of 1916 as amended. Okay. meron mga Section 10 and Section 12 not applicable sa Philippines daw. Huwag na natin basahin. So, basahin na lang natin Section 14. Upon the certification of the Secretary of Commerce that the foreign commerce of the U.S. in its competition with that of foreign nations is prejudiced by the provisions or any of them of the Title I of this Act or by the laws of any foreign country or countries relating to the carriage of goods by sea, the President of the U.S. may, from time to time, by proclamation, suspend any or all provisions of Title I of this Act for such periods of time or indefinitely as may be designated in the proclamation. The President may at any time rescind such suspension of Title I hereof, and any provisions thereof which may have been suspended shall thereby be reinstated and again applied to contracts thereafter made for carriage of goods by sea. Any proclamation of suspension or rescission of any such suspension shall take effect on the date named therein, which date shall be not less than 10 days from the issue of the proclamation. Any contract for carriage of goods by sea subject to the provisions of this Act, effective during any period when Title I hereof or any part thereof is suspended, shall be subject to all provisions of law, now or hereafter applicable to that part of Title I which may have thus been suspended. So hindi ko lang alam kung hindi ko lamang alam kung itong batas na ito ay meron ng na-repeal na o na-amend na o na-supersede na ibang batas. Pero ang importante lang naman meron tayong idea about the Carriage of Goods by Sea Act, no? And kung meron mang bagong batas na papalit o susundin na sa pangangasiwa ng carriage of goods by sea, meron tayong idea kasi April 16, 1936 pa to. Bago pa yung World War II, di ba? So at least may idea pa rin tayo sa pangangasiwa o pag-interpret ng batas. So muli, ito nga pala si Lolo Ray. Salamat sa pagsama nyo sa akin magbasa ng business organizations, bulk sales law, Act 4164 o yung act na pinagbabawal yung pagtataas ng presyo ng mga prime commodities pag may kalamidad, at yung Carriage of Goods by Sea Act. So mag-pray muna tayo. Glory be to the Father, and to the Son, and to the Holy Spirit, as it was in the beginning, is now, and ever shall be, world without end. Amen. In the name of the Father, and of the Son, and of the Holy Spirit. Amen. So, sana samahan niyo ulit ako magbasa-basa next time. Magandang libangan din to, magbasa, unawain yung batas, at subukan natin itong ipaliwanag in layman's term.